You're listening to Portfolio, the property law podcast from Davis Blank Furness.
Hello and welcome to Commercial Property Insights, the podcast from Davis Blank Furness, where we unpack the legal complexities of commercial property in a way that's practical, accessible, and genuinely useful for our listeners. I'm Rosie Corch, a partner in the commercial property team. I focus on transactional work, helping businesses, SMEs, and high net worth individuals navigate property acquisitions, disposals, and leases.
And I'm Seán Hackett, the head of the Property Litigation Department here at Davis Blank Furness. And whilst Rosie's dealing with deals, I'm often picking up the pieces when things go wrong. Disputes over lease terms, forfeiture proceedings, dilapidations, claims, that sort of thing. It's a different perspective, but both sides of the coin are crucial to understanding commercial property properly.
Indeed. Today, we're tackling what I think is one of the most commercially significant aspects of commercial leases: Tenants Alienation Provisions. Now, for those listening who are not familiar with the jargon tenants alienation, it simply refers to a tenant's ability to deal with their lease by either assigning it to somebody else entirely or subletting all or part of their property. It's an absolutely crucial consideration for any business taking on commercial property.
Absolutely, and I'd add that it's equally crucial for landlords to understand these provisions, because getting them wrong can have significant financial consequences. I've acted on a case where a landlord had to pay substantial damages to their tenant because they mishandled the consent process, and the tenant's business sale fell through on the assignment issue alone.
Yeah, that's a perfect example of why we need to dedicate an entire episode to this topic. Now, we'll be covering a lot of ground today. We'll start by explaining the difference between assignments and underletting. Then we'll delve into the Landlord and Tenant Covenants Act 1995, which fundamentally changed how liability works in commercial leases. And then we'll finish by discussing Authorised Guarantee Agreements, or AGAs as they are commonly known, which have become a standard feature in modern commercial leases.
Yeah, and throughout we'll be trying to give practical examples that are relevant to SMEs, high net worth individuals with investment properties, and businesses of all sizes who might be thinking about either taking on new premises or looking to exit from premises they no longer need. It's worth emphasising that we're going to be discussing tenants alienation today. We won't be dealing with the topic of landlords' assignments.
Perfect. So let's start at the beginning. Seán, when a business tenant finds themselves in a position where they need to deal with their lease, perhaps they're downsizing, or they've outgrown their space, or they're relocating, what are the fundamental options available to them?
Well, Rosie, there are two main options. Assignment is one and underletting of the whole is the other. And it's really important to understand the distinction between the two because there are very different legal and practical consequences involved. An assignment of the whole of the premises is essentially a transfer of the entire lease to a new tenant. The original tenant steps out, though, as we'll discuss later, they may not be entirely off the hook, and the new tenant steps into their shoes, taking on all the obligations under the lease.
And that new tenant becomes the direct tenant of the new landlord, doesn't it? So there's a direct landlord and tenant relationship created.
Exactly. So the original tenant ceases to have any ongoing relationship with the landlord under the lease, at least in theory. And then contrast that with underletting of the whole of the premises, which is also sometimes called subletting or subleasing. Here, the original tenant grants a new lease out of the existing lease. So you end up with a three-tier structure. The landlord at the top, the original tenant now acting as what we might call him the intermediate landlord in the middle, and then you have the subtenant at the bottom.
And that's a crucial distinction because with underletting, the original tenant remains fully liable to the head landlord for all the covenants in the head lease. If the subtenant fails to pay rent, the tenant still has to pay the head landlord. If the subtenant damages the property, the tenant is still on the hook to the head landlord.
Precisely, the tenant is sandwiched in the middle with obligations running upwards to their landlord and rights and obligations running downwards to their subtenant. It's a more complex arrangement, but it can be advantageous in certain circumstances. So for example, if a business is going through a temporary downturn and wants to sublet part of their premises as opposed to the whole of the premises to generate some income, for example, but they're confident they'll need the full space again in a year or two, well, underletting part gives them that flexibility.
That's a great example. I've worked with several SME clients who've used partial underletting exactly in that way. I'm thinking of one particular client actually, a marketing agency who had taken a 5-year lease on a full floor of offices when they were expanding really quickly. They then hit a quieter period and didn't need all that space. Rather than trying to assign the whole lease and move to a smaller property, which would have involved significant costs and disruption, they underlet about half of the floor to another complementary business. It was a graphic design studio. That generated some income to offset their rent, and when their business picked up again about 2 years later, they didn't renew the underlease and they took the whole space back.
Yeah, that's a textbook example of underletting working well. But I should add a word of caution. Underletting only works smoothly if it's properly documented and if the subtenant is reliable. I've dealt with litigation where a tenant underlet to a subtenant who then failed to pay the rent and caused damage to the premises. The tenant was still liable to their landlord for the full rent and for the cost of the repairs, and then they had to pursue their subtenant separately.
Yeah, absolutely. Can be risky. That's why the due diligence on a proposed subtenant is really important, even though legally it's the tenant and not the landlord who's primarily at risk if the subtenant defaults. So now let's talk about the restrictions that would typically appear in leases. It's very rare to find a commercial lease that allows a tenant complete freedom to assign or underlet without any restrictions at all.
That's right. Alienation covenants generally fall into 3 categories. And in our 3rd podcast, we covered these categories when we discussed consent in respect of alterations. I need to put down a marker, Rosie, because consents in terms of alteration covenants and consents in terms of alienation covenants are not the same. And our focus today is in relation to alienation. So first, you have the absolute covenants, which completely prohibit assignment or underletting. Now, these are relatively rare in modern commercial leases for old premises, though you might see them in leases of part of a building where the landlord wants to maintain very tight control.
And I should mention that even with an absolute covenant, it is not necessarily the end of the road for a tenant who needs to deal with the lease. You can always approach the landlord and have a chat and ask for consent as a matter of grace. Now, the landlord isn't obliged to agree, but depending on the circumstances, they just might. I've negotiated several consents like that, where the landlord could see that the proposed assignee or the subtenant was actually more financially robust than the existing tenant.
Yeah, quite. But just because it's an absolute covenant doesn't mean that you can't ask. I suppose that's the point. It just means that the landlord is under no obligation to agree it. And if they are prepared to consent, well, they can set whatever terms they want in exchange for doing that. So let's move to the 2nd category. It's a qualified covenant which prohibits assignment or underletting except with the landlord's consent. And I want to pause there because if the alienation covenant in the lease states that the tenant shall not assign or underlet except with the landlord's consent, you might be forgiven for thinking that that was the full extent of the covenant, but it isn't. In every such qualified covenant which prohibits assignment or underletting without the landlord's consent, Section 19, subsection 1 of the Landlord and Tenant Act 1927 implies a qualification into the covenant that the consent is not to be unreasonably withheld. Now, the effect of Section 19, subsection 1 is to therefore convert all qualified covenants which prohibits assignment or underletting into fully qualified covenants. And then we move to the 3rd one, and this is by far the most common category in modern commercial leases, is the fully qualified covenants which prohibit assignment or underletting without the landlord's consent, such consent not to be unreasonably withheld.
So, when it comes to covenants in relation to alienation, you've got 2 types of covenant. Firstly, your absolute covenant. That's no entitlement to assign or underlet, and the landlord can be as unreasonable as they want. And a fully qualified covenant. So the landlord's consent to the assignment or underletting cannot be unreasonably withheld.
Exactly, but that isn't the end of the matter because those words, consent is not to be unreasonably withheld, triggers the Landlord and Tenant Act 1988. And under Section 1 of that Act, when a landlord receives a written application for consent to an assignment or underletting, the landlord has a duty within a reasonable time to give consent, except where it is reasonable not to do so. The landlord must also serve written notice of their decision, and if the consent is refused or given subject to conditions, the landlord must specify their reasons or conditions in that written notice.
And the burden of proof is on the landlord, isn't it? It's for the landlord to show that they acted reasonably and within a reasonable time. It's not for the tenant to show that the landlord acted unreasonably.
Exactly. And that is set out in Section 1, subsection 3 of the Act. And that's a crucial shift from the common law position. The 1988 Act puts the onus firmly on the landlord.
So you mentioned the landlord has to provide their written response within a reasonable time. So what is a reasonable time?
Yeah, good question. And this has been the subject of considerable case law over the years. But the leading authority is probably the Go West versus Spigarolo. It was decided by the Court of Appeal in 2003. And in that case, the court made it clear that what constitutes a reasonable time is a question of fact. In Midland Bank PLC versus Chart Enterprises Inc. in 1990, a delay of almost 3 months in notifying a tenant of a decision was held to be unreasonable. In Dongbang Minerva versus Davina Limited 1995, it was considered that 28 days from receipt of the written application and the references by a landlord was a reasonable period. So, Rosie, generally speaking, we're talking about weeks rather than months.
Absolutely. If you're a landlord considering an application for consent, remember you need to act promptly and please take proper advice. I know we would say that, but we really mean it.
We do.
If you're going to refuse consent or impose conditions, you need to make sure you've got reasonable grounds and that you set those out clearly in writing. You cannot just sit on an application hoping the problem will go away. If a landlord fails to comply with their statutory duties under the 1988 Act, the tenant can sue for damages under Section 4 of the Act for breach of statutory duty.
Absolutely, yes. And those damages can be substantial. In one case that came before the courts, which was Design Progression Limited versus Thurlow Properties Limited in 2004, the landlord was found to have deliberately delayed giving consent as a strategy in the hope that the tenant would give up and surrender the lease, enabling the landlord to grant a fresh lease at a more profitable rent. And the court awarded not only compensatory damages, but also what we call exemplary damages of £25,000 to mark their disapproval of the landlord's conduct.
So, we've established that landlords must act reasonably and within a reasonable time when considering applications for consent. In terms of a landlord refusing to give consent, when can they reasonably refuse to give it? What are their legitimate grounds for saying no?
Yeah, that's where it gets interesting because reasonableness is always fact specific. However, there are some established principles, and the leading case on reasonableness is International Drilling Fluids Limited versus Louisville Investments. Now, that was decided by the Court of Appeal in 1986, and in that case, Lord Justice Balcombe set out a number of propositions, including that the purpose of a covenant against assignment without consent is to protect the landlord from having their premises used or occupied in an undesirable way or by an undesirable tenant or assignee.
So, it's about protecting the landlord's legitimate interest in their property, but it's not about allowing the landlord to act capriciously or to extract additional value beyond what the lease entitles them to.
Precisely. And a landlord can reasonably refuse consent if the proposed assignee or subtenant is financially weak and likely to be unable to pay the rent or comply with the covenants. That's a legitimate concern about the covenant strength of the proposed tenant.
In practice, that means that landlords will typically ask for financial information about the proposed assignee or subtenant. That'll be things like accounts, references, evidence of financial standing. For a limited company, it would probably include several years of audited accounts, details of their business, references from bankers and current landlord. For an individual, you've got evidence of personal wealth, income, and maybe guarantees.
Exactly. And it's reasonable for a landlord to seek that information and to make an informed assessment based on it. Now, what's not reasonable, Rosie, is for a landlord to refuse consent simply because they think they might get a better rent from someone else or because they want to frustrate the tenant's plans for some ulterior motive.
Another common scenario is where the proposed assignee wants to use the premises for a different purpose than the existing tenant. Can a landlord refuse on those grounds, Seán?
Well, it depends, Rosie. If the proposed use would be a breach of the user covenant in the lease, then it's generally reasonable for the landlord to refuse the consent, though there are complications there that we should touch on. If the proposed use would comply with the user covenant in the lease, then it's harder for the landlord to justify refusing consent simply because they don't like that particular use. Now, the complication is the decision in the case of Ashworth Fraser Limited versus Gloucester City Council, and that was decided by the House of Lords in 2001. That case held that a landlord could reasonably refuse consent to an assignment if they believed that the assignee would use the premises in breach of the user covenant, even though the landlord would have remedies against the assignee if that happened. Now, in that case, Rosie, the House of Lords said you had to ask what a reasonable landlord would do in the particular circumstances of the case rather than applying a rigid rule. So that gives landlords more scope to refuse consent to assign where they have genuine concerns about how the proposed assignee will use the property. But the key word is genuine. The concern has to be one that a reasonable landlord would have and be supported by evidence and not just a pretext for refusing consent for some other reason.
Okay, so reasonableness in the context of making a decision on the application for consent to assign is by reference to what a reasonable landlord would do when asked to consent in these particular circumstances. Now, we've been talking about the mechanics of seeking consent and what happens when a lease is assigned or underlet, but we haven't yet addressed what is perhaps the most significant question for both landlords and tenants. Who remains liable for the tenant covenants after an assignment? And that brings us neatly to the Landlord and Tenant Covenants Act 1995, which fundamentally changed the law in this area.
That's right. The 1995 Act was a major reform for what are called new tenancies. And those are leases that were granted on or after the 1st of January 1996. And for our purposes today, we'll focus on new tenancies under the 1995 Act, since that's what the vast majority of commercial leases now fall under. Now, Section 5 of the 1995 Act provides that when a tenant enters into an authorised assignment, I'll labour that point, authorised assignment of the whole of the premises demised to them under the lease, they are automatically released from the tenant covenants of the tenancy. Now, they stop being liable for rent, for repair, for all the obligations that previously bound them. A version of that applies if the tenant enters into an authorised assignment of part of the premises, and this will be the release from the obligations that previously bound them in respect of the assigned part. Now, those releases only apply to authorised assignments. So if the tenant assigns the lease in breach of the alienation provisions in the lease, they don't get the release under Section 5 of the 1995 Act.
So where there is an authorised assignment, the assignee steps into the outgoing tenant's shoes. They become bound by the tenant covenants under Section 3 of the Act, which provides the benefit and burden of the covenants will pass automatically on assignment.
That's right. Now, this was seen as a much fairer approach to tenants, but landlords were understandably concerned about losing the security of being able to pursue the original tenant if things went wrong. So the 1995 Act introduced a compromise mechanism, and it's called the Authorised Guarantee Agreement, or it's nicknamed the AGA for short.
And AGAs have become completely central to modern commercial leasing practice. So we're going to spend some time unpacking exactly how they work.
Yeah, so an authorised guarantee agreement is essentially an agreement by which the outgoing tenant guarantees the performance of the tenant covenants by their immediate assignee. So Section 16 of the 1995 Act sets out the framework. And the key point is that the new tenancy, this is where the alienation covenant is a qualified covenant, which, as we discussed earlier, means it requires the landlord's consent. The landlord can require, as a condition of giving that consent, that the outgoing tenant enters into the AGA.
So I'll play the landlord here. Yes, I will consent to the assignment, but only if you guarantee that your assignee, the new tenant, will perform the tenant covenants. So crucially, Section 16 makes it clear that the landlord can do this without it being regarded as unreasonable refusal of consent, provided that the lease either contains an express provision permitting that or the circumstances justify it.
Yeah, and in practice, virtually every modern commercial lease granted since the 1995 Act came into force includes a provision that specifically allows the landlord to require an AGA as a condition of consent to assignment. So it's become standard practice, Rosie. So when you're negotiating a new lease, you'll see a clause that sometimes you'll think of, and I'm going to paraphrase it here, is it says that the tenant shall not assign the whole or any part of the premises without the landlord's prior written consent, such consent not to be unreasonably withheld in relation to an assignment of the whole, and it shall not be unreasonable for the landlord to require as a condition of consent that the tenant enters into an authorised guarantee agreement.
Exactly. And it's worth noting that this is one of the permitted conditions that the landlord can specify under Section 19(1)(a). Under that section, landlords can specify in the lease the circumstances in which consent may be withheld or the conditions subject to which they may be granted. And those circumstances and conditions are then deemed to be reasonable.
Yeah, so if the new lease says that the landlord can require an AGA, that's automatically deemed to be a reasonable condition. The tenant can't argue that it's unreasonable. Now, the position on a lease renewal is a bit different, but that's a discussion for another day, Rosie.
Indeed it is. So, what does an AGA actually mean for the outgoing tenant?
Well, under an AGA, the outgoing tenant guarantees their immediate assignee, so that's the new tenant, that they'll perform all of the tenant's covenants and they'll pay all the sums due under the lease. And if the assignee, which is the new tenant, well, if they default, for example, by not paying rent or by failing to repair the property, then the landlord can call on the outgoing tenant under the AGA to make good the default. And it's important to understand the limits on an AGA, because under Section 16, subsection 4 of the 1995 Act, an AGA only lasts for as long as the assignee remains the tenant. So if that assignee then under an authorised assignment assigns the lease onto a third party, then the original tenant's liability under the AGA, well, it comes to an end. They're not guaranteeing the performance of subsequent assignees, only their immediate assignee.
So under the 1995 Act, with an AGA, the tenant is only liable for their immediate assignees to the next tenant's period of occupation.
Yeah, so that said, an AGA can still be a significant ongoing liability, particularly if the assignee gets into financial difficulties shortly after taking the assignment. I've been involved in a case where an outgoing tenant has ended up liable under the AGA for rent, arrears and dilapidation costs, where the outgoing tenant have had to take on new leases following the insolvency of that assignee.
Absolutely. And that's why it's important for tenants to do proper due diligence on any proposed assignee before they agree to an assignment and before they enter into an AGA. You need to satisfy yourself that the assignee, so the new tenant, is financially sound and likely to be able to meet the obligations under the lease. Don't just accept the landlord's decision that the assignee is acceptable. Do your own assessment.
Yeah, that is good advice. And I'd add that if you're negotiating a new lease as a tenant, you should think about whether there are any circumstances in which you might want to try and negotiate that an AGA won't be required or will be required in only limited circumstances. For example, if you're a strong covenant and you're concerned about being tied to the performance of a subsequent occupier, you might try to negotiate that an AGA will only be required if the proposed assignees have a lesser financial standing than you are.
Yeah, I've seen that type of provision in some high-end office leases. If you've got a really strong corporate tenant, The lease might say that an AGA will be required unless the new tenant's net worth exceeds a certain threshold or unless the assignee is a PLC with a certain market capitalisation. It recognises ultimately that if you're assigning to someone who's clearly financially better off than you are, there's no real benefit to the landlord in requiring you to provide a guarantee. Another option may be to link the timescales for the provision of an AGA to the break date within the lease. That way, a tenant is only bound under either the lease or the AGA up to the point where they could have brought the lease to an end under the break.
Yeah, and I'm sure some landlords would push back on that, saying, why should I lose the AGA if the tenant doesn't exercise the break? But of course, whether you can negotiate all of these things depends on your bargaining position. And in a difficult market where the landlords are competing for tenants, you might have leverage to negotiate away or limit an AGA requirement. And in a strong market where landlords have their pick of tenants, you'll have much less room to manoeuvre.
Now, there's an additional layer of complexity we should mention. What happens if the original tenant had a guarantor? If the tenant had, say, a parent company or directors who guaranteed the tenant's obligations, what happens to their guarantee when the tenant assigns?
Yeah, this is covered by Section 24 of the 1995 Act. So when a tenant is released from a tenant covenant on assignment, any guarantor of the tenant is also automatically released from their guarantee. So the guarantee doesn't continue after the tenant has assigned pursuant to an authorised assignment.
But, and this is important, just as the landlord can require the outgoing tenant to enter into an AGA, the landlord can also require any guarantor of the outgoing tenant to guarantee the outgoing tenant's obligations under the AGA. In effect, the guarantor is guaranteeing the AGA. This is known as a GAGA. So you end up with a slightly complex structure. Bear with me. So you've got the assignee is liable as the tenant. The outgoing tenant guarantees the new tenant's performance under the AGA. And the guarantor of the outgoing tenant guarantees the outgoing tenant's performance under the GAGA. Okay, so that's clear. One really important point, which is often overlooked, is that Section 17 of the 1995 Act requires the landlord to notify former tenants and their former guarantors within 6 months of any default by the current tenant in relation to the payment of a fixed charge. So that's an ascertained sum of money.
Yeah, exactly. And Section 17 provides that if a landlord is going to pursue a former tenant or former guarantor for that thing that they call the fixed charge, and that typically will include rent, service charge, and any liquidated damages, well, the landlord must first serve a notice on the former tenant or former guarantor within those 6 months of the charge becoming due. And the notice has to inform them that the charge is now due and that the landlord intends to recover it from them.
And if the landlords fail to serve those notices within 6 months, they lose the right to recover that particular charge from the former tenant or former guarantor, though they don't lose the right to recover future charges. It's often called the Section 17 notice, and it's a crucial protection for former tenants and former guarantors.
That's right. Section 17 does not apply to current tenants and current guarantors. It's just former ones. So for the sake of completeness, I will mention, Rosie, at this point, Section 18 of the 1995 Act, which gives the former tenant or former guarantor who pays under the AGA or the guarantee the right to request what we call an overriding lease from the landlord. And you might want to explain what that is, Rosie, if I'm not putting you on the spot.
Sure, that's fine, Sean. So essentially, if you're having to pay the current tenant's obligations under your AGA, you can require that the landlord grant you a new lease of the property that sits in a layer between the landlord and the current tenant's lease. You effectively become the current tenant's landlord. That gives you direct control over the property and the ability to forfeit that lease if they continue to fail to pay rent or default in another way.
Yeah. Now, we've spent a lot of time on assignment, but we should turn to underletting as well because the considerations there are different. Rosie, perhaps you could outline the key differences in approach.
Certainly. As we mentioned earlier, underletting creates a 3-tier structure. So you have the head landlord, then you have the intermediate tenant, that is the original tenant who is now subletting, and at the bottom, the subtenant. From the intermediate tenant's perspective, this is important because they remain fully liable to the head landlord for all the covenants in the head lease throughout the entire term of the underlease. There's no automatic release, as there is with an assignment under the 1995 Act.
So if a tenant wanted to sublet rather than assign, they'd still be on the hook for the entire annual rent to the landlord, regardless of whether their subtenant paid them. If the subtenant caused damage, the tenant would be liable to repair it under their repairing covenants to the head landlord, so it's a continuing liability.
Exactly. So why would a tenant choose to underlet rather than assign? Well, there are several scenarios. A tenant may only want to dispose of part of the premises and keep some space and sublet the rest. That's very common in office buildings where a business has taken too much space and wants to generate some income from the surplus. I've seen law firms, accountants, various professional businesses sublet individual floors or suites within their premises. The second scenario is where the tenant wants to retain flexibility to get that space back. If you assign, you've given up your lease. You can't get it back unless the assignee agrees to assign it back to you, which they are not obliged to do. But if you underlet for a fixed term, say 3 years, and then at the end of that 3-year period, the sublease comes to an end, and you get the space back automatically.
Though we should mention that the Landlord and Tenant Act 1954 there, shouldn't we? If the subtenant is in occupation for business purposes, they may have security of tenure under the 1954 Act, which could make it difficult for the intermediate tenant to get the space back.
That's absolutely right. We covered the 54 Act in detail in episode 2 of this series, so backtrack if you're interested. But just to recap, if a sublease is protected by the 54 Act, the subtenant has the right to remain in occupation at the end of the term and to request a new tenancy. The intermediate tenant would need to have grounds for opposition under Section 30 of the 54 Act to refuse to grant that new tenancy.
So if you're going to grant a sublease and you want to be sure you can get vacant possession back at the end of the term, you need to ensure that the sublease is contracted out of the 1954 Act, and that requires you following the specific procedure we discussed in episode 2, serving the health warning notice on the subtenant, getting the statutory declaration or simple declaration before the sublease is then completed.
Exactly. And that's absolutely standard practice now for subleases, where the immediate tenant wants certainty about getting their space back. So now let's talk about the terms of your sublease. This is important. A sublease cannot be on better terms than the head lease. What I mean by that is, if the head lease prohibits certain uses, the sublease has to as well. It has to contain the same or tighter prohibitions. So if the head lease requires the tenant to repair, the sublease must impose at least the same repairing obligation on the subtenant.
And the sublease must be for a shorter term than the head lease. You can't grant a sublease that expires after your lease expires. There needs to be at least 1 day of the reversion, and in practice, many head leases specify that any subleases must be at least 3 days or even a year shorter than the head lease.
That's right. When I'm drafting, I normally have a 10-day window just to deal with anything falling out. And the rent under subleases can be more or less than the rent under the head lease. There's no restriction there. In fact, it's quite common for intermediate tenants to sublet at a premium to their head rent if market conditions have improved, or at a discount if market conditions have worsened. The key is that the intermediate tenant is still liable for the head rent, regardless of what they're receiving from the subtenant.
Yeah, what about the alienation provisions in the sublease? If the head lease allows assignment with consent, can the subtenant assign their sublease, Rosie?
It all depends on what the sublease says. The intermediate tenant has complete control over the terms of the sublease they grant, subject to any overriding requirement that they mustn't breach their own head lease. Many intermediate tenants include quite restrictive alienation provisions in subleases, for example, prohibiting assignments altogether or allowing it only with the consent of both the intermediate landlord and the head landlord. That gives them maximum control.
Yeah, and from a risk management perspective, that would make sense. So if you're going to remain liable to your head landlord throughout, you want to maintain as much control as possible over who's occupying the premises and what they're doing there.
Now, just as with assignment, most head leases require the tenant to obtain the landlord's consent before subletting. And the same statutory protections as we discussed earlier, so that's the Landlord and Tenant Act 1927 and the Landlord and Tenant Act 1988, apply equally to applications for consent to underlet.
So the head landlord has to act reasonably and again within a reasonable time when considering any written application for consent to sublet. And the same principles apply as to what's reasonable, and the landlord can consider financial standing of the proposed subtenant and the proposed use and so on.
Although there is one important difference in practice. Because the intermediate tenant remains liable to the head landlord for all the covenants in the head lease, head landlords are often somewhat more relaxed about consenting to subletting than they are about consenting to a wholesale assignment. The head landlord knows they've still got the intermediate tenant on the hook, so there's less risk from their perspective.
That's true, though I'd caution against head landlords being too relaxed. If the subtenant causes damage or breaches covenants, the head landlord can pursue the intermediate tenant. But if the intermediate tenant then goes into insolvency, well, the head landlord could be left out of pocket. So it's still important, Rosie, for head landlords to take a proper view of the proposed subtenants.
Absolutely. And many head leases now include provisions that allow the head landlord to specify conditions for subletting, similar to conditions for assignment. So, for example, the head lease might say that the head landlord can require the subleases in a prescribed form, or that it must be on full repairing terms, or that it must be contracted out of the 54 Act.
And provided those conditions are specified in the head lease itself so that the tenant knows about them when they enter into the head lease, they're going to be deemed to be reasonable under Section 19, subsection 1A of the Landlord and Tenant Act 1927, as we discussed earlier in the context of assignments. We've covered a lot of ground on both assignment and subletting. It might be helpful to take a step back and give some strategic advice to businesses about when each option is appropriate, Rosie.
Yeah, good idea. So, from a business perspective, if you no longer need the premises at all and you want to be completely free of the ongoing obligations, assignment is usually the better option, assuming you can find an acceptable assignee and the landlord consents.
Yeah, and with assignment, once you have assigned and your AGA liability ends, which happens when your immediate assignee assigns on to somebody else, you're completely free. You have no further obligations, and you can contrast that with the scenario with underletting, where you remain liable to the head landlord through the entire term of the sublease.
That's right. So assignment is cleaner from an exit perspective. However, there are a few scenarios when subletting may well be preferable. First, as we've discussed, if you only want to dispose of part of your property. Second, if you think you might want the space back in the future, you're subletting for flexibility.
Yeah, and third, if you're concerned about the financial strength of potential assignees, if you assign to someone who looks acceptable now but turns out to be weak, you're on the hook under the AGA until they assign on. Whereas if you sublet, you're on the hook to the head landlord anyway, but you have more control because you're the subtenant's landlord. You can forfeit the sublease if they breach, and you can grant the sublease on terms that give you more protections.
Yeah, that's an interesting point. I think in practice, though, most occupational tenants prefer to assign if they can, simply because it removes the ongoing management burden. Being an intermediate landlord is work, and most businesses would rather focus on their core business than manage properties.
Yeah, that's a fair point. So what about from a landlord's perspective? How should landlords think about alienation provisions when they're granting a new lease, Rosie?
Landlords want flexibility to control who occupies their property, right? But they also need to be realistic. If you make alienation provisions too restrictive, you make the lease less attractive to potential tenants. A tenant who knows they might need to downsize or relocate in the future may well be reluctant to take a lease where they can't assign or sublet without the landlord's consent.
So most modern leases have a fully qualified covenant for assignment of the whole consent, not to be unreasonably withheld, and then they specify the conditions the landlord can require, such as the AGA, the GAGA references and so on. That gives the landlord control, whilst also giving tenants certainty about what will be required on their applications.
Exactly. And I think the provisions allowing the landlord to specify conditions under Section 19(1)A of the 1927 Act have been really helpful in achieving that balance. Landlords can set out their requirements clearly in the lease, and the tenants know where they stand.
Yeah. What about subletting? Should landlords allow that always, or what's the position, Rosie?
To be honest, I think most landlords are comfortable allowing subletting of the whole with consent for similar reasons. It makes the lease more marketable. Subletting of part is more contentious, as we discussed earlier. Some landlords prohibit it altogether, others allow it with consent. I think the trend is towards allowing it with consent, but giving the landlord quite tight control over the terms of the sublease.
Yeah, and that makes sense because subletting of part can affect the value and the management of the property, and landlords should have the right to ensure that any sublease is on terms that protect their position.
Are there any recent developments, Sean, in the law that businesses should be aware of in this area?
Well, the fundamental framework has to be the 1995 Act, the 1988 Act, and the 1927 Act. Now, for many years now, everything's been pretty much stable under that, but there continue to be cases that clarify the operation of those statutes. And one area that generates ongoing litigation is what constitutes reasonable time under the 1988 Act for the landlord to respond to an application for consent.
Yeah, I think there's been increasing scrutiny of landlords who impose conditions that go beyond what is reasonable. For example, requiring an assignee to undertake works to the property or requiring changes to the lease terms when the application is just for a straightforward assignment. Courts have been willing to find that such conditions are unreasonable unless there's really good justification.
Yeah, and another area where I've seen disputes is around the information that landlords can reasonably require from proposed assignees or subtenants. Landlords sometimes ask for very extensive financial information, and tenants push back saying it's disproportionate. Now, there's a balance to be struck, Rosie. The landlord is entitled to enough information to make an informed decision about covenant strength, but they can't go on a fishing expedition.
I think the biggest pitfall is not reading and understanding the alienation provisions in your lease when you take it on. Too many tenants sign leases without really thinking about what will happen if they need an early exit. They then get a nasty surprise when they discover they can't assign without an AGA, or they can't sublet part at all.
So the time to negotiate alienation provisions is before you sign the lease, Rosie, not when you want to leave.
Exactly. If you've a strong covenant, maybe you're a large corporate or a high net worth individual, you may have the leverage to negotiate away or limit the AGA requirement, or to negotiate a more favourable subletting provision. But you need to think about it at the outset.
Mm-hmm. Another pitfall I see is tenants who agree to an assignment or sublease without doing proper due diligence on the proposed assignee or subtenant. They're so keen to get out of the property that they accept the first person who comes along, and then that person turns out to be weak and defaults, leaving the outgoing tenant exposed under the AGA.
Yeah, that's a classic mistake. And on that, outgoing tenants who don't properly understand the extent of their ongoing liability under an AGA. They think they're leaving the property and they're free of obligations. Then 2 years later, they get a demand for rent arrears and dilapidations costs, and they're really shocked.
Yeah, education is so important. That's why we're doing these podcasts. And tenants need to understand that entering into an AGA is entering into a potentially significant financial obligation. They should think about it seriously as they would think about giving a bank guarantee or taking on a new lease themselves.
Yeah, absolutely. And on the flip side, a pitfall for landlords is not responding to applications for consent promptly and properly. I've seen landlords who just sit on applications for weeks or months without responding, or who refuse consent without giving any reasons. And they then find themselves being sued for damages under the 1988 Act.
Yeah, absolutely. And the message, I suppose, Rosie, for landlords is take these applications seriously, seek advice promptly, and respond in writing with clear reasons if you're refusing consent or if you're imposing conditions. And I suppose the key thing I'd say from us from a litigation point of view is you should document everything.
Agreed. Well, Sean, I think we've covered an enormous amount of ground today. Should we try to distill this down for some key takeaways for our listeners?
Yeah, that's a good idea. I think the first key takeaway is understanding the difference between assignment and underletting. Assignment is a transfer of your lease. Underletting is granting a new lease out of your lease. They have very different implications for your ongoing liability.
Second, understand the Landlord and Tenant Covenants Act 1995 and how it changed the law for leases granted after 1st of January 1996. As a tenant, you're automatically released from liability when you assign, but the landlord can require an authorised guarantee agreement, or an AGA, to guarantee your immediate assignee's performance.
And third, if you're entering into an AGA, treat it as a serious financial commitment. Do proper due diligence on the proposed assignee. Make sure you're comfortable that they can perform the lease obligations, because you're going to be on the hook if they don't.
Fourth, for landlords considering applications for consent to assign or sublet, remember your statutory duties under the Landlord and Tenant Act 1988. Act reasonably, respond in writing within a reasonable time, and give clear reasons why you're refusing consent or imposing any conditions.
Yeah, and fifth, if you're subletting, make sure the sublease is properly drafted to protect your position as the intermediate landlord. Mirror the covenants in the head lease, include appropriate mechanisms for recovering costs, and consider contracting out of the 1954 Act if you want certainty about getting the space back.
And finally, we're nearly there. Think about alienation provisions at the outset when you're negotiating your lease. I know I would say it, but honestly, don't leave it until you want to exit. That's when you have the least leverage.
Yeah, I think that's an excellent summary. And I'd add one overarching point. In all of these transactions, take proper professional advice. The legal and financial implications of getting alienation wrong can be very significant. A relatively modest investment in good legal advice at the outset can save you a great deal of money and stress down the line.
Absolutely. Whether you're a landlord or a tenant, whether you're an SME, a high net worth individual, or a larger corporate, these provisions affect you, and they're worth getting right.
Well, I think that's a perfect place to wrap up today's episode, Rosie. Next time on Commercial Property Insights, we'll be turning to the ongoing costs during the lease term. We'll be looking at rent-free periods, rent structures, rent reviews, including the dreaded and likely to be soon banned upward-only rent review, and service charges, including caps and exclusions. It's all about understanding what you're really going to be paying over the term of your lease and how to budget for it effectively.
That's going to be a really practical episode for businesses trying to understand the true cost of their property. We'll be bringing in examples from real cases and giving concrete advice on how to negotiate those provisions. Until next time, thanks for listening to Commercial Property Insights from Davis Blank Furness. If you've got questions on anything we've covered today, get in touch by visiting our website www.dbf-law.co.uk. Take care.